Welcome to this explainer. Today, we're unpacking a really fascinating South African legal thriller. It's all about workplace power, minority rights, and basically the fundamental right to protest. We're diving into the landmark constitutional court case of NUMSA versus Bader Bop. And look, this isn't just some dry, dusty dispute over labor law. Oh no, it's a massive showdown about what happens when the strict, literal wording of a statute slams head-on into the supreme law of the land, the Constitution.
So, let's just tackle the core question right out of the gate. If you're in the minority, do you completely lose your right to strike? I mean, put yourself in this situation. Imagine you and your colleagues join a union you genuinely believe in, right? But another union holds the absolute majority in your workplace. Are you just silenced? Are you legally banned from going on strike to demand basic representation? Well, this was the exact real-world dilemma facing hundreds of workers right around the turn of the millennium. And, as we'll see, the answer ended up completely redefining industrial relations in South Africa.
All right, let's jump right into Section 1, the factory floor dispute.
Let me set the scene for you. The year is 1999, and we're at the Bader Bop auto leather factory in Garankwa, just outside Pretoria. They've got about 1,000 semi-skilled and unskilled workers there. Now, if you look at the power dynamic on the factory floor, it was heavily skewed. The majority union, GWUSA, had 66% of the workforce. They were the undisputed heavyweights, right? Meanwhile, NUMSA was definitely the underdog, representing just 26% of the workers, with the last 8% totally unrepresented. So Bader Bop management recognized GWUSA as the big boss, the majority player, and gave them all the organizational rights. But here's the thing, NUMSA's 26%? That still meant over 250 actual human beings who desperately wanted their chosen union to represent them.
So how did this blow up into a massive conflict? Well, NUMSA wasn't coming in trying to run the whole factory. They simply wanted their shop stewards recognized so they could help their own members with standard, everyday grievance and disciplinary stuff. But the employer, Bader Bop, they flatly refused. They essentially told NUMSA, look, you aren't the majority, so no shop stewards for you. Understandably frustrated by this total roadblock, NUMSA did what unions do when talks break down. They formally declared a dispute and notified the company they were going on strike. Bader Bop's reaction? They immediately sprinted to the courts to get an interdict to shut the strike down.
Which brings us to Section 2. What does the law actually say? To understand why the employer felt so confident trying to block this strike, we kind of have to open up the rule book. Passed in 1995, the South African Labor Relations Act sets up this very clear hierarchy of rights in the workplace. Under Sections 12 and 13, smaller unions that are considered just sufficiently representative, like NUMSA was here, they get basic rights. Things like accessing the workplace to hold meetings or getting union dues deducted via stop orders. But if you look at Sections 14 and 16, the law strictly locks away the right to recognize shop stewards and the right to information disclosure exclusively for majority unions. So Bader Bop just looked at this and went, hey, the law says shop stewards are for the majority, you don't have the majority, end of story.
And you know what? That argument actually worked in the lower courts. The Labor Appeal Court handed down a deeply divided ruling that gave the employer the win. The majority of those judges figured that because the statute specifically saved shop stewards for the majority union, the law basically implied a total ban on minority unions like NUMSA striking for those exact same rights. Their logic was, if you let a minority union strike for something Parliament explicitly saved for the big guys, you'd wreck the whole statutory framework. Therefore, they ruled the strike was unlawful and unprotected.
But NUMSA was definitely not ready to throw in the towel. Let's move to Section 3, the constitutional catch.
Okay, so here is where it gets really interesting. The absolute crux of the matter is this. Can a regular labor statute actually override a fundamental human right? On one side of the ring, you've got the Labor Appeal Court's super strict reading of the Labor Relations Act, literally locking minority unions out. But in the other corner, you have Section 23 of the South African Constitution. And Section 23, it doesn't stutter and it doesn't leave room for footnotes. It simply declares every worker has the right to strike. So we have a literal head-on collision here. The lower court's strict reading of a labor law is acting as a direct restriction on a constitutionally guaranteed right that belongs to every single worker, whether they're in the majority or not.
Let's zoom out a bit for Section 4, the Global Labor Standard.
So how on earth do you resolve a massive clash between a specific labor law and a broad constitutional right? Well,
You look beyond your borders. The Constitutional Court looked very closely at international law, specifically International Labour Organization Convention 87, which South Africa actually ratified back in 1996. This convention fiercely protects freedom of association. It says, flat out, that workers have the right to establish and join organizations of their own choosing. It's all about worker autonomy. If you force someone to rely on a majority union they totally disagree with, or you refuse to let their chosen minority union step into a disciplinary hearing, you are severely compromising their freedom of association.
And actually, the ILO's supervisory committees have debated this exact tension. They've explicitly stated that while majoritarian systems where the biggest union gets the most perks are perfectly fine, minority unions absolutely cannot be regulated out of existence. Crucially, they still have to be allowed to represent their own members in basic, individual, disciplinary, and grievance matters. Because think about it, if you strip a minority union of the ability to protect its members when someone's facing getting fired or disciplined, you're stripping that union of its entire reason for existing.
All right, here we go. Section 5, the final verdict. Armed with the heavy-hitting guarantees of the Constitution and the backing of international law, the Constitutional Court delivered this incredibly elegant and powerful verdict. They completely overturned the lower courts and handed a massive victory to NUMSA. But here's the brilliant part. Rather than just striking down the Labor Relations Act, the court zeroed in on a genius little escape hatch built right into the law, Section 20. This section explicitly states that nothing in the Act stops parties from concluding a collective agreement that regulates organizational rights. The court interpreted this as a massive green light. Basically, the law actually allows unions and employers to negotiate rights completely outside of that strict statutory framework of Section 14.
And this is the absolute genius of the ruling. They redefine the whole framework. The court explained that there is a massive difference between a statutory right and a bargained right. The law doesn't actually forbid minority unions from having shop stewards. It just means they don't get them handed over automatically on a silver platter like the majority union does. Because they aren't granted automatically by law, minority unions have to work for them. And how does a union work for something? Through collective bargaining. And what's the ultimate engine powering collective bargaining? You guessed it, the right to strike. Therefore, NUMSA was perfectly 100% within its legal rights to strike to force Bader Bop to give them shop stewards.
Let's bring this all together in Section 6, why this matters today. To wrap up this explainer, let's take a look at the massive ripple effect of this David versus Goliath victory. The Bader Bop judgment fundamentally shifted the balance of power in South African labor relations. Let's look at exactly what it achieved. First up, it safeguards worker dignity. As Justice Cato Reagan noted, in a constitutional order, workers absolutely cannot be treated as coerced employees. You cannot force them to be represented by a majority union they didn't pick. Second, it aggressively protects the constitutional right to strike, proving that a simple statute cannot just erase a fundamental freedom. It empowers minority voices, making sure they aren't just drowned out by sheer numbers, and confirms that collective bargaining and the industrial action that gives it teeth belongs to absolutely everyone.
Which leaves us with a really powerful reality to ponder. We so often think that in a democracy, the majority takes all, and the minority just has to fall in line, right? But as the Constitutional Court proved in the Bader Bop case, when it comes to fundamental human rights, the answer is a resounding yes. Even a minority voice can be loud enough to literally stop the machines. It leaves us to wonder, how might minority voices, empowered by the fundamental right to strike, reshape the future of your very own workplace? Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll catch you next time.